So, good evening, everyone. My name is Maria Varaki. I'm a lecturer in international law at the Department of War Studies, and I'm also director of the MA in Peace, Security, and International Law. Today, I'm very, very happy because we have a stellar panel with us, very esteemed colleagues and international legal scholars who, of course, are going to engage in a discussion about what else international law in Iran. Before I give the floor to the speakers, I would like, of course, to introduce them briefly, not that they need a very long introduction. So our first speaker is Professor Marko Milanovic, who is Professor of Public International Law at the University of Reading Law School, and also Raoul Wallenberg, visiting Professor of International Human Rights Law and Humanitarian Law at the University of Lund, among other things, and until very recently also co-editor of the Eagle Talk. Our next speaker is Professor Yuval Shany, who holds the Hersch Lauterpacht Chair in Public International Law at Hebrew University Faculty of Law. And among other things, he's also a senior research fellow with the Israel Democracy Institute. Our two other speakers, final speakers, is Professor Rebecca Hamilton, Professor of Law at the American University Washington College of Law. And Rebecca comes and writes, she's the executive director of Just Security, and also she has a very, very long professional practical experience on atrocity prevention before she joined academia. Our final speaker is Professor Tom Dannenbaum, who recently joined in 2025 the Law School of Stanford University, and he also belongs to the editorial board of Just Security. Tom also has extensively written on the broader things of international peace and security regarding aggression, siege, starvation, and other very important themes within this context. So, thank you very much, all of you, for being here with me, for accepting this very short notice invitation. I'm looking forward to our discussion. And the reason that I have invited all of you is because all of you wrote immediately afterwards, after the events that started on 28th of February and the initial strikes of US and Israel on Iran, very important interventions. In this regard, I do believe that your ideas, your thoughts, and the things that you put on the table that have triggered further discussion, and I'm looking forward to these ideas with you. So having said that, I believe that the people, the audience who is going to watch this recording is very much familiar with the facts, what happened since the last 2 weeks. It's 14th day today with the initial strikes of US and Israel on Iran, the reaction of Iran, the escalation of the conflict all over the region, and the series of legal questions that all these events trigger regarding both use of bellum, using bellum, but we'll say broader concerns of security, such as energy security, maritime security, and other issues. So I'm sure that our panelists are going to address these issues, but I would like to start this discussion from another perspective. I think one key characteristic of the last 2 weeks was the engagement with international legal argumentation, which all international lawyers, we do pay attention to that. So here I have identified, I would say, 3 themes. One, the first theme was the legal argumentation, or at least the attempt to legally justify those strikes. The 3 first mostly involved actors. Whether those legal arguments were tenuous or not, we heard a lot about self-defense. We even heard about kind of humanitarian intervention, about regime change, but there was some argumentation with international law. The second trend that we saw regarding the language of international law was different political statements. So what is very characteristic is that apart from the key actors that in the US, Israel, and Iran, we saw several other senior politicians make reference statements about the death or not of international law, to what extent international law should protect countries that violate international law, to what extent Europe in particular should remain the guardian of the rules-based international order, or to what extent we're at a very critical point where we are done with the old world and we should prepare for another one. That was very much coming from the European side. The third trend regarding legal argumentation, I would say, was the reaction of several states before international fora, particularly within the Security Council, whether it was the initial session after the strikes, but also a couple of days ago when a resolution was adopted regarding the reaction of Iran, the attack of Iran on the Arab Gulf states. And there one could identify whether from partial silence to partial condemnation regarding international law, but also invocation of international law and some other references about who can invoke international law, whether this is pure cynicism or to what extent particular states invoke international law in bad faith. So within this broader context about the death, the life, the revival, the recuperation of Article 2, paragraph 4, the exaggerations about its death, other arguments about double standards, selectivity, cynicism, or what I try to argue, the need for a new vocabulary, you came up with particular pieces where you made particular proposals on the table. And although you brought very different views, I very much hope that this discussion, will be extremely rich and fruitful for our audience. So before any further delay, I would like to start with Marko. Marko, you wrote the first reactive piece on 28th of February, where the title of your piece in Eagle Talk was that these attacks were illegal, in parentheses, again, right? If I remember correctly, that was it. And then you made a very, very clear legal analysis. So I would like to invite you to highlight the key legal arguments, and also what do you think is at stake? How do you assess the overall situation during the last 2 weeks regarding the prohibition of use at bellum, but also some broader implications? Thank you very much.
Thanks, Maria, and hi, everyone. It's great to be with you this evening. We're 2 weeks in, as you said, Maria, and I don't think anything has changed from a use at bellum perspective. I think things are clear, and they've been clear from the start. It's clear, in my view, that Israel and the United States have violated Article 2, Paragraph 4 of the Charter. They violated in a massive use of force, which by its scale, by the gravity of the consequences on the ground, by the fact that, the entire leadership of Iran was decapitated on day one, I think clearly crosses the threshold into aggression. It's not a war of territorial conquest, but to my mind, it's clearly aggression. And that's where we are from that standpoint. It is also quite clear that in how it chose to react, Iran also violated Article 2, Paragraph 4 against all of its neighbors in the Gulf. The reason why we have these two violations is because none of these states has been able to either plausible claim or remain within the confines of lawful self-defense. And that's, I think, simply where we are. Now, the bigger question is what are the consequences for those states? What are the consequences for the international legal order as such, and so on, for this illegality? But the illegality is what it is, And it's not the first time we're here. There have been many, many uses of force by various states over the past decades or whatever, or since the Charter's inception, where you had a plain violation of Article 2, Paragraph 4. There is nothing terribly unusual about this one either. Yeah. What's perhaps depressing is that we see this kind of repeat of the intervention that we had past summer, but on a much larger scale. That again, 2 weeks in, we have no idea how this is going to end. That from a policy perspective, the whole thing seems to be run by people who seem to have very little idea what they're doing, what they're even trying to achieve, and that they pay no heed to international law at all. On the other hand, that's not really terribly surprising because these people don't pay much heed to their domestic law either. Yeah. So if you look at the current American government, or they look at the current Israeli government, or if you look at the Iranian government, it's not like they're law-abiding generally. So that's where we are, and I don't think it's really that terribly complicated. The reason why they're not within the limits of lawful self-defense is because none of the conditions for self-defense were met in the case of what the United States and Israel did. It depends a bit on how you want to look at what the sort of armed attack, quote unquote, either ongoing or imminent by Iran would be, whether it's simply the nuclear threat, or whether it's a wider missile threat, or whether it's the use of proxies. I mean, it depends on how you look at that. The problem is that the rationales of the two states using force, Israel and the United States, have themselves also been, shifting. Partly that's also exacerbated by the fact that if you look at the formal kind of responses they've given in the Security Council, they're a hodgepodge of different theories. There's very little legal language there. It's mainly really political language. And it's really hard to distill what their legal justification is. But even on the best, most plausible case they don't have one. And they similarly have no case that in this particular moment in time, on the 28th of February, 2026, it was the measure of last resort. No other option was possible to deflect whatever Iranian armed attack but the use of force. Similarly, Iran has no plausible way of arguing that its attack on Gulf states, including attacks on ships carrying oil, including attacks on civilian infrastructure in the Gulf states, could plausibly remain within the confines of necessity and proportionality. Had Iran responded only by targeting US bases, maybe we would have a hard case, but that's not what we have. Yeah. What we had is an all-out imposition of retaliation by Iran on its neighbors. Whether that's a good strategy for them or not is a policy question on which I don't want to pronounce, but legally, the situation was clear. And the fact that the Security Council in this climate can condemn Iran in the way that it condemned Iran tells you that Iran's response can also plausibly not be defended. So that's where we are. Now, in terms of where we take it from here, like what does this mean for the legal order? If this was an isolated event, if it was just a one-off, you could say, well, there's been breaches of the law all the time. And of course, international law is not just the law on the use of force, it's everything else as well. The problem is that we're in a spiral of non-compliance with various basic rules of international order, and you have the most powerful states in that international order losing their commitment to it, even on a rhetorical kind of basis. And that is a very, it is a very negative experience for our chosen profession and the legal order that sort of we deal with. And that's just how it is. How it's going to end, though, we have no idea. Right? It can end up in a complete spiral of non-compliance. It can in a total disruption of the current order. It can lead to some transformation of the current order to something better, even though that seems highly unlikely, or it can lead to some kind of partial collapse. But that's where we are. I don't think anyone can plausibly say this is a good time, to be an international lawyer. But on the other hand, it's not a good time to be a domestic lawyer either in many countries.
Very true. Thank you for that, Marko. I think I will build up on that, on the spiral of non-compliance, and you say, and I will move to Yuval's piece in Just Security, where Yuval, the title of your piece with Amichai Cohen is that the international community is at a crossroads, at a crossroads over Iran. And there, at the beginning of this piece, you identify a gap as you, if I understood correctly, between international lawyers who condemned what happened, and we speak about the legality of the initial of the attacks and the waging of war, but also the reaction, as you say, of several states to these events, where, according to your description, it feels, that international law does not seem capable of properly responding to concerns of international peace and security. And then with Amikai, you propose the awakening with a question mark, if I understood correctly, of the legitimate but illegal, but also the so-called right to self-preservation. And you provide some additional thoughts. You say that this is also problematic to a great extent about the international law, but also this is your proposition somehow to the state of art. So would you like to further elaborate on that, building from Marko?
No, you summarized everything perfect.
Oh my God, I'm sorry. I'm sorry for that.
No, I will say a few things. So first, I agree with a lot of what Marko said. And that is that on the bottom line is I agree, and I agree that the attack by Israel and the U.S. is very difficult to justify within the charter, if at all. I mean, and we lean we lean in the piece, and I also. My conclusion is that there had been a violation of the charter framework. I am not as unambiguous as Marko, because I think there are some issues on which there is a debate. There is this preemptive self-defense theory, which I don't buy, but it does exist, and in that context, there is an argument which people like Mike Schmidt have raised before concerning the last window of opportunity, which could be also raised in this case, though I'm not persuaded by this theory to begin with. And then I also think that the issue of when does an armed conflict begin and when does an armed conflict end is a bit more complicated in some of the analysis that we have seen, because an armed conflict, a war, is not is not a series of separate incidents. It has to be regarded as a whole, and sometimes there are time lags between one strike and the other. But I do think here that the combined effect of having ceasefires and having a relatively long time lag does require a lot of heavy lifting from an evidentiary point of view by Israel and the United States. And so far, this burden has not been met. So I tend to agree with the general analysis that this is outside the framework of the charter. But our piece was basically about a different issue. It was not about the legality. It was really about this tremendous gap between the general consensus, the broad consensus. I won't say wall to wall, but there is, I would say, 90. I think Marko, in a different context, wrote that 90% of international lawyers would come on one side. And I think this is another instance where at least 90% of international lawyers would come on one side. And the way in which states had responded, and this time it was not just fringe states or states that would blindly follow everything the United States would do. So it's not Argentina's Milei. I mean, these were statements very quickly by countries that have a very strong status and very long commitment to the international rule of law, including Canada, where we just heard 2 months Carney have this wonderful speech about the middle powers upholding international law. We had the German chancellor basically saying, forget about we're not going to lecture our allies. We had ministers from Belgium and Netherlands, who basically says, international law is not the only framework of analysis here, or international law is broken. And even those who condemn the attack, some of those who condemned the attack, like Meloni in Italy and Macron in France, basically said either that, yes, it's unlawful, but the system is broken, and therefore there is not much that we can do. Or Macron says, well, they operated outside international law, but the blame is on Iran. Iran is the one to blame for the situation. And when you fast forward not so many days to the Security Council resolution 2817, it is quite shocking, right? That you have a resolution that is basically condemning only Iran. And I think Iran has in some respect, it has a rightful grievance, right? Because the Security Council came down and hard on Iran, condemning it and demanding that it stops its act of aggression, including, by the way, the use of proxies. So it's basically a very comprehensive and very strong Security Council resolution. And the parallel Russian motion, this was not, I mean, it was a very interesting situation because the Russian motion, I mean, the Russian draft was actually very moderate. It didn't lay the blame on anyone. It didn't name anyone. It just called on all parties to stop the violence. And this was not even a case of a veto. There were only 4 countries who voted in support of this resolution. So you have a situation where you have a professional consensus that is very strong on the illegality of the initial attack. And then you have a political universe that is operating in a very different trajectory and seems to be, at this point in time, generally critical of Iran, of course, with some few exceptions. And we try to understand in the piece to provide some explanations for this gap. I don't know how am I doing on time, Maria, but we offered 3 possible explanations. We were not actually advocating for any of these options. We were just laying out. We actually think that all options on the table are bad options. So we do not endorse any of them. But I think it is important for us to have a conversation about where are we headed. And we are offering these 3 options as potential frameworks, potential framings for this discussion. One is that this is the Merz Munich speech narrative that the rule of law is dead. It's not that the rule of law is dying, the rule of law is dead, and therefore we should forget about international law, and we all should basically find a new job, maybe teaching history or IR or something else. The other option, and I think obviously this is not, I mean, it's hard for us to accept this, partly because, like you said, Maria, the parties do use international law. International law is still being used. So it still has some currency, it still has some relevance. So it's not completely lost, and I'm not going to talk about other areas where international law may be working better than in other areas. The second possibility is that we are seeing something which looks like a phenomenon that we have seen before also, and we call it in our little piece this illegal but legitimate framing, where we have seen in a number of occasions before. Kosovo is one example, but we've seen this also in Syria, and we've seen this in Liberia and in other contexts where there have been military operations that did not conform to the 4 corners of the charter, but yet were not strongly condemned and in fact enjoyed significant political support. Monica Hakimi, who's not here, and we hope to have her on the top. Maybe you could bring her to a second setting, Maria. She wrote a piece 6 or 7 years ago, maybe a bit more, I think 2018, which did actually highlight a number of these situations where the Security Council effectively endorsed, implicitly, if not explicitly, violations of Article 2.4. And she tried to put it within a New Haven kind of language, separating the myth of Article 2.4 and the operational code of the actual practice. And we were arguing that this maybe is another case which goes in the same direction, where although the charter has most probably been violated, because Iran is seen as a very dangerous and rogue actor, both to its neighbors and also to its own people, there has been, on the facts of this case, states were not willing to basically defend Iran and to invoke international law in its defense. They didn't want to be, so to speak, useful idiots for the Iranian regime, and therefore they went back. So that's a second framing that we are offering. And the third, which is maybe, and that has to do with the twist in this case, and that is that it's not only about a rogue state that is also massacring its own people, it's also a country which has nuclear ambitions and is posing a concrete and long-standing threat to another country in the region. This time it's Israel, but of course it's also threatening other countries in the region. And this is perceived as an existential threat, as the kind of, by Israel and also I think by the United States, it is seen as an existential threat for Israel. And within that framework, I think we do have some history in international law regarding the old right to self-preservation that effectively said that in those extreme cases, a state may be at some level justified in responding to these exceptional threats. If you recall, the advisory opinion on nuclear weapons has language that goes in this direction, that when a state is facing a threat to its own existence, a catastrophic threat, maybe in those situations, the court is not in a position to say, so the undertone is maybe here international law ends to constrain states. I'll just note, and with this I will finish, that this is not a new debate. This idea of catastrophic threats was also discussed by the expert panel that the Secretary General convened in 2004, and they came up with a report, A More Secure World, at that time. And they did discuss in this report the possibility of what happens should we talk about a situation where a catastrophic threat is presented only in terms of imminence, or should we go beyond imminence in those cases? And their call was at that time, no, we should insist on imminence, because in all other cases, you have to go and make your case to the Security Council. I think the moment in time we are at is that there is a very limited faith that the Security Council can help in these cases. I think in 2004, there was still some residual optimism about the ability of international institutions to come through. I think 22 years later, this optimism is much lessened, and this is why we are seeing states moving in this direction. So just maybe the final sentence that I will say, we think all three options are bad. But what we think is the world forward is for international lawyers to identify that we have here a problem. We have here a problem in the sense that there is a strong, we can basically think that all states are wrong. It's like the joke about the person who sees traffic coming in his direction and is basically saying, why is everyone driving on the wrong side of the road, right? So if everyone, basically almost everyone, is saying the system is broken, the rules do not provide us with a good solution, maybe we have to take another look at how our laws, at our rules operate in this geopolitical environment, and how our institutions operate in this geopolitical environment. But just being complacent and saying it's unlawful, period, this is not gonna advance us very, very much further. So I'll stop here, Maria.
Thank you very much, Yuval. And without any further delay, Rebecca and Tom wrote a response to Yuval and Amikai, and your title was Aggression Simple and Plain. And there, in very strong terms, of course, you challenge Yuval's Yuval and Amikai's arguments, but also, if I understood correctly, your piece, you emphasize that the way I read it was that the problem is not within the system, how the system is structured, apart from the veto. The problem is how states deal with the system. So you made references to Uniting for Peace resolution, to reform of the Security Council, to the usage of regional organizations, that there are tools, but those tools were never utilized because all this action was already predetermined in a dismissive tone towards the system. So Rebecca and Tom and Rebecca, who would like to take the floor to elaborate much better than me on this very rich piece. Thank you.
So thanks very much, Maria. I'm happy to start us here. I think the areas where there is consensus across everybody involved in this conversation so far is that we have a fairly clear violation of the UN Charter here. Some of us would say it's absolutely unambiguous, and Yuval would maybe say that there's some grey areas at the margins, but I think even he would agree that in this particular case, what we've seen is a violation of the UN Charter. My own view is that it's not just a violation, but a brazen violation, a violation that is connected with no genuine effort to articulate a plausible legal rationale. And the combination of those two things, in addition to the fact that one of the agents of the violation in this context is the global hegemon, and in addition to the fact that it's coming on the back of several decades of the erosion of the prohibition on the use of force, or at least erosion of its normative understanding by some of the key powerful states, and the fact that it's happening in conjunction with a brazen Russian aggression in Ukraine, all of those are clear challenges to this particular legal paradigm, and they are, I think, ultimately existential threats for the law governing the resort to force, and therefore things that international lawyers need to be thinking about in terms of the viability and trajectory of this particular prohibition. But where I think we disagree is how to understand this particular violation in relation to that trajectory and in relation to what comes next. And in particular, I think we disagree about whether this is plausibly characterized as the manifestation of dissatisfaction with the existing legal paradigm, and that it's in some way, therefore, a principled violation of the rules, either with a view to a better legal framework or with a view to responding to the demands of legitimacy in a context in which the law is not itself responsive to those. And I think on that front, it's just not persuasive to me at all to suggest that it's properly characterized as manifesting dissatisfaction with the legal framework, because if there were dissatisfaction with the legal framework, it would need to be the case that there would be a rule that's imaginable, that would be responsive to that dissatisfaction and applicable to all states and available in reverse. And I think it's very clear that the United States and Israel have not undertaken this operation pursuant to a principle that they would recognize as available to other states in relation to their own conduct, whether it's about posing regional threats, whether it's about engaging credibly in crimes against humanity or other atrocity crimes, or whether it's about pursuing or holding nuclear weapons. On none of those grounds could these states point to a principle that allows them to engage in use of force here, that they would be comfortable with being invoked by another state in relation to their own conduct. Instead, what they're relying on is the fact that they are distinctively powerful within the system, and so they're relying on the fact of that power to be the shield against that kind of reverse application. So that's not a dissatisfaction with the rules, that's an assertion of power that seeks to be unconstrained by any rule and a reliance upon the power of the state in question rather than an alternative legal framework or even imagining an alternative legal framework. And that's also why this is not a principled violation of the law. There are, of course, contexts in which one can imagine a principled violation of the law. We have it in domestic law in the context of civil disobedience. There are many ways in which we could articulate this kind of idea. But not only does this particular operation comport with no principle that the parties involved would recognize as available to others, they also haven't articulated any principle of that kind. They haven't engaged in any multilateral engagement at all at the international level with any significant international organization that would have endorsed the operation in advance, whether through the legal mechanism of the Security Council, through the plausibly legal mechanism of Uniting for Peace in the General Assembly, or through any other international organization that could have endorsed the operation. They didn't seek that engagement because they're not seeking to engage in a principled violation of the law and gain normative buy-in across the system for a new principle or a new structure. And so, from my perspective, those factors, in addition to the way that the war is now being conducted, strikes on desalination plants, strikes on oil depots causing black smoke over Tehran, strikes on schools and hospitals, the Secretary of Defense this morning issuing a denial of courted declaration in a public press conference. All of these things are not consistent with the kind of narrow and sober tailoring that would normally accompany a principled violation of international law. And so in all of those respects, I think we have to call this what it is, which is an unchecked, illegal assertion of power that is not pursuant to dissatisfaction with the legal framework, but is pursuant to dissatisfaction with the very notion of being legally constrained as a powerful actor in the system. I have additional thoughts about how we as a profession should think about our role in responding to that, but maybe I'll just pause there and hand it over to Beck, and then we can come back to that if necessary in the next iteration.
Thank you very much, Tom. Becca?
Yeah, thanks, Tom, for saying so eloquently the concerns about reading into the party's statements or behavior something that would amount to a principled law-breaking moment. And I would just kind of add further, I push back on the idea that the reactions of states that are not the direct parties here can be read as sort of almost everybody saying that there is a problem with Article 2.4. I think there is kind of more nuance to read into that, particularly when you understand the context of the US's sort of global hegemonic role, the way that states are needing to duck and cover and hedge in response to that. And I think if we kind of did a scan through states' reactions, paying careful attention to those issues, there'd be actually fairly little left that is indicative of an opinio juris type approach that would say there is general dissatisfaction with Article 2.4 as a matter of law, as opposed to needing to hedge their bets in relation to action that the US in particular is taking because of just global power at the moment. So all of that, you know, both the lack of principled violation, lack of any evidence of principled violation with respect to the states parties involved, and also my read on the states' reactions as not being anything close to a sort of majority conviction that opinion juris is moving in a different direction on this, make me skeptical of the idea, and we can get to this, that the role of international lawyers at this point is to do something other than simply call a spade, right? I think it was intentional, the aggression plain and simple title that Tom put on our piece, because I don't see it as our role to come up with justifications that even the states themselves aren't promoting. What I will say, though, is the fact that we are not seeing widespread condemnation, even to the extent that can be explained by geopolitical factors rather than a concern about the law itself, should give us pause, right? I'm not saying that it's not important to pay attention to that, but I want to take a step back for this whole conversation for a moment and just consider the sort of basic wisdom of what the Charter set up with respect to the use of force and Article 2.4. And in that, it established this extremely high and objective threshold for when states can resort unilaterally to the use of force, right? Our Article 51, or our general customary international law on self-defense, we are looking at our actual or our imminent armed attack. And there is good reason for wanting to set that very high threshold for unilateral action by states. Now, that is one side of the system. The other side, of course, is where we have a much lower triggering threshold, right? Threat to international peace and security, for engaging the multilateral mechanisms that can end up authorizing the use of force under Chapter 7. And what has concerned me about the way this conversation has unfolded over the last couple of weeks is that if we call a spade, what we have is a violation of Article 2.4 because it doesn't meet the high threshold that is set up under self-defense. And the idea that the response to that would be to lower the threshold for self-defense seems to me to be a deeply problematic response in a context where what we do have, I would say, majority views on is that there is a problem with the other side of the system right now, that the UN Security Council mechanism, as was configured in the wisdom of the post-Cold War era, is not fit for purpose today. And so I think my frustration is, rather than trying to read into this moment a sort of widespread concern with the high threshold that we've set for the unilateral resort to the use of force, when all we actually have is a violation that for geopolitical reasons hasn't been as effectively called out as we would like it to be, that we instead should be looking at why isn't the other part of the system working for so many people around the world. And that seems to be the much more wide-ranging and important conversation for us to be engaging with as international lawyers when you think of populations truly around the world that are affected by the way that Security Council apparatus is currently stymied by the veto. And I think the thrust of sort of what we've got to at the end of our piece was to be drawing attention back to that system. And the problems that the veto mechanism has put into place that extend far beyond, I don't think they're even relevant in this particular case, but are very, very relevant and very urgent for a population in Ukraine or Myanmar or Gaza, or like name your place around the world. That seems to be a much more pressing priority for the legitimacy of international law.
Thank you very much, Rebecca and Tom, for this initial intervention. I will go back to our first speaker, Marko. What do you think? What is your take after these three rich comments here? What do you think? And maybe you would like also, to explore also, to talk about the role of international lawyers, if you have thoughts about that. I think that would be interesting for all of us, because it goes back.
So I agree completely with Beck and Tom. So I don't want to pile up on Yuval in that sense. I mean, I just think, illegal but legitimate is really a kind of argument you can make at any point. It's not an argument that ever went away, and you can make it in any context, right? So long as you accept a positivist conception of the law, you can find a reason to break it, yeah? So either because the legal system as a whole is unjust, or because a particular legal rule in that system is unjust or leads to unjust outcomes, so civil disobedience being one of them. So, I mean, I don't have a problem with that, right? As a basic notion, right? There will be situations where I can imagine, breaking the law for a higher end might be a good idea. I mean, in and of itself, that's not a philosophically terribly complicated problem. This is not that situation. These are not that people. You see what I mean? Like Donald Trump and Benjamin Netanyahu are not the high moral evaluators of the world today who are doing things for a higher purpose. I mean, do you see what I mean? Like, it's a bit like saying, that person who, like a settler guy who goes to the West Bank and is uprooting some Palestinian villager there, is breaking the law for a high purpose. I mean, that's what he thinks. Do you see what I mean? Like, but in reality, it makes no kind of connection to any kind of objective sense of morality, right? Even if you're doing some kind of lesser evil analysis. So the one thing I would really object to when it comes to Yuval's sort of argument is this idea of existential crisis, yeah? Like, I understand why people in Israel are feeling very anxious about Iran. Like, if I was there, I would feel very anxious about Iran. I understand why 90% of people in Israel kind of support the military action, although only 20-something% in America do, yeah? But Iran is really not an existential threat to Israel in the way that, for example, Russia is to Ukraine. There's no real evidence of that. If you want to balance the books about who killed more people from what side, I don't think the balance goes out in the Iranian direction, if you see what I mean. So yeah, someday they have not, proven to be themselves to be some kind of crazy people who would bomb Israel with an atom bomb, even though Israel itself already has nuclear weapons. I mean, the whole thing is a narrative that was constructed, especially on the right wing in Israel, over a long period of time in a society that has become more and more brutalized through the use of force. And that argument has now become so perfectly mainstream. But I don't think either reality or morality justify what we are seeing, if I can put it that way. Yeah. So I don't think we need higher maths here to see what's going on. If the question is what should we do as lawyers, I mean, I don't know. I mean, certainly the least we can do is to call it out. We also need to call out our states. I mean, those of us who are not in the United States or Israel. It's also obvious why they're not condemning the United States. It's obvious. Yeah. If you see Spain condemning the United States, and then the same day Donald Trump says we're going to cut off all trade with Spain, you understand why all states in the world are being very cautious in the kind of very brutal dog eats dog kind of dynamic we have going on right now. So I don't think we need to overthink this. My main concern, I think the main issue here is the need to preserve fidelity to the law, to the idea of legal constraint of power domestically. That's my main concern. That's what I think is the main failing. That's what's afflicting most of our societies to greater or lesser extent. That is certainly what's afflicting Israel and the United States. And that's the big battle that needs to be fought, because people like Trump or Netanyahu don't want to be constrained by any kind of law. It's not just international law.
Thank you, Marko. Fidelity, I wrote down. Yuval.
Yes, so I'm not a big fan of either Donald Trump, and even a lesser fan of Benjamin Netanyahu, as you can imagine. So it's not really about, for me, it's not about having any trust in these personalities. But I do disagree with Marko on the issue of the existential threat. Iran is an existential threat to the state of Israel. It's and this also goes to the question of the principle justification. This is an exceptional situation. Ukraine, Russia, maybe. Even I would say that even that case is somewhat different in the sense that Russia is a malicious actor, but it seems to be acting at some level on a rational basis. I cannot say that with regard to Iran, this has been the way in which the Islamic Republic has conducted itself. It has picked a fight with Israel for no reason, from our perspective, no reason whatsoever. And this has become a religious dogma. And the idea that you have a state whose almost raison d'etre has become to destroy another state, and it is putting all of its resources, almost all of its available resources, in a variety of projects, which are all aimed in that direction. I mean, a nuclear program, a ballistic missiles program, a proxies network, terrorism. And it is going again and again and again. And the international community is trying to contain it. There are sanctions, there are agreements, but ultimately they do not produce a result. They just postpone what, from their point of view, is inevitable. They have the clock at the square, which is running down. I mean, it does the time run out until Israel is destroyed. This is not an ordinary international relations situation. This is something that I think a country like Israel has good reasons to experience this as an existential threat. And this is why in Israel, it's not a political issue. I mean, it's not a right-left issue. There are very few voices, and it's also not this government or that government. Labor governments saw Iran as an existential threat, and Likud governments. So I would say that this is quite a different situation. And I think that in those cases, yes, there would be a justification to reconsider how does international law deal with catastrophic threats when the Security Council is unwilling or unable over the years to deal with this threat. I think this is a challenge. and we need to deal with it. And I think here there are some, you can think of some doctrinal developments in the same way that we have seen doctrinal developments with regard to non-state actors after 9/11. And I think we've also seen I've mentioned before the report, a more secure world, where this actually also took basically gave a stamp of approval on imminence for anticipatory self-defense. So the idea that the charter is not stuck in the world of 1945 and deals with some evolving threats, such as these extreme existential threats. Again, ideally, we would want the Security Council to be the party that arbiters on this, but we have also to accept the reality in which the Security Council doesn't do properly its job over the years. And the numbers of violations, including maybe the numbers of existential threat, I mean, Ukraine and Russia is another good example, shows that we have here, it's not a one-off. We have a systemic problem here that we need to deal with. Now, with regard to, I think I agree with most of what had been said regarding illegal but legitimate. I'm not a fan of this doctrine as a legal doctrine, but I accept, like Marko said, there are cases where morally complying with the law is at some level results in immoral outcomes. And again, ideally, the Security Council should get us out of the mud in these circumstances. But you can imagine some exceptional situations where you would see states actually ignoring the letter of the law. Syria was maybe an example of this in recent years. I think Iran could have been a similar example, especially if this would have been framed as humanitarian intervention, but it was not framed in those terms, and I don't think that there has been a bona fide argument in that regard. So that has to do with regard to opinio juris. With regard to illegal but legitimate, I think I agree with you, Becca, on opinio juris. I never made the claim, and we never made the claim that states are motivated by a very analytical understanding of the charter. The claim was different. That states are actually basically putting international law on the shelf. They're not trying to change international law. They're simply either ignoring it or saying it's irrelevant, or it's one among a number of considerations. Whether this could lead over the years to change in opinio juris, maybe, but we didn't make this claim, and I'm not making this claim at this point. So maybe just two final thoughts. One on the Security Council. Yes, I mean, the Americans, they have not used the I mean, Donald Trump's views on the UN. This is part, even the teleprompter doesn't work. So that's, I think, frames his way of thinking about the utility. But eventually they did actually, after they started, they did come to the Security Council, and they got very favorable resolutions. So when we are saying go to the Security Council, we also need to factor in the fact that they did effectively got the implicit blessing of the Security Council, because Iran was condemned and they were not condemned in the same settings. So this is something we also need to, when trying to analyze the role of institutions in legitimizing or delegitimizing force, this is a factor we need to reckon with. And do international lawyers just call a spade a spade? I would probably take exception to this. Yes, we often do that, but we're also in the business of identifying areas in which the law has to be reformed. We can argue maybe about timing, maybe not today, but when we are seeing Russia, Ukraine, and we are seeing Gaza, and we are seeing Venezuela, and we are seeing Iran 1 and Iran 2, and so this is spreading like wildfire. Maybe at some point we also need to look back at whether the rules are operating effectively, whether the institutions are operating effectively, and if not, then we should come out with sensible and workable reforms. So that's the point. So just saying you're violating the law and no one pays attention in the political universe, this is not a great outcome for us. It makes us, as a discipline, semi-relevant. So this is the point I wanted to make.
Thank you, Yuval. I have many thoughts, but I give the floor immediately to Tom and then to Becca.
So I'm not sure I want to get looped into a quagmire on exactly how existential or not the threat posed by Iran is, but I would just ask Yuval to flip the analysis and think about the threat that's posed to Palestine by Israel and the degree to which the litany of things that he laid out is not only present there, but has actually been operationalized and applied to a greater extent, and then raise the question of if that's sufficient to say, now we should be able to act outside of legal paradigms, what are the implications in reverse for what's lawfully available vis-a-vis Israel? Does it mean that there could be a decapitation strike on the political leadership in Israel because it poses this threat to the viability of a Palestinian state? What other kinds of extra legal mechanisms would be available on the basis of this theory? To be clear, I don't subscribe to that theory, but I think if one adopts it and invokes it in this context, one has to be able to apply it in other contexts where the evidence of the threat to the viability of a state is not just about prospective action, but about ongoing and expanding action in the current moment. And so I think we just need to be consistent here and say, if we're talking about a demand for legal reform or a demand for a principle that's extra legal that would legitimate action outside of existing law, we have to be able to apply it concretely across cases in a way that is responsive to the equal status of states within the system. On the question of how we should react in this moment as international lawyers, I think it is appropriate for international lawyers to think about legal and institutional reform, but not legal and institutional reform that is seeking to accommodate the interests of powerful states to the point at which they're essentially exempted from any legal constraint and allowed to apply their power without legal constraint. We might accommodate them and create a system that no longer recognizes the equality of states or sovereign equality, and we would then maybe see more law compliance, but it wouldn't be a legal system worthy of the name. It wouldn't be a legal system that adheres to the rule of law. And so if we're thinking about legal reform, it has to be in a context in which we're thinking about legal developments that would be responsive to the equal status of peoples and states globally. And then in thinking about that and thinking about the current moment, I think it's unambiguously a profound challenge for international lawyers if we have a legal system that is being rampantly violated by the most powerful actors in the system. I don't think it means the law is dead. It's a treaty rule. It has not fallen into desuetude. We don't have subsequent practice by the parties to that treaty that evinces an agreement among those parties that the rule is no longer applicable, because many of those states continue to assert the rule, as Beck mentioned earlier, and continue to insist on its bindingness. So the rule is still formally alive as a legal matter. Practically, its viability is under severe threat because powerful states are acting in violation brazenly and across multiple situations. And so then our challenge as lawyers is think about what it means to say that the majority of the states in the world continue to recognize a rule that is formally legally binding when powerful states are acting as rogue states in the system in a way that no longer respects that rule. What does that mean for that rule as a legal matter? What does it mean for our role as international lawyers? But I don't think the answer is at all to start to try and accommodate the violators by adjusting the rule to placate them, particularly given that that adjustment is ultimately only going to placate them if it recognizes their authority to use force and not states outside of their particular group to use force under similar circumstances.
Thank you, Tom. Becca?
Yeah, I mean, so to be clear, I'm not saying the only role of an international lawyer is to call a spade, but I do think in a moment of violation, that is absolutely part of our job. And it's not a great time to use that as the jumping off point for sort of exploring theories that states are not themselves advancing. But, you know, I would agree with you 100% that the international system is not in good state right now, and I echo Marko in looking also domestically to what is happening. And part of this in the domestic story is convincing ordinary citizens of the value of the rule of law, and sort of perversely what the consequences of the attack on Iran that are already being felt by Americans in terms of gas prices might be one of the most effective ways of getting that engagement. So, the work has to happen on the domestic level, absolutely. And I just echo Tom in, to the extent that there is a concern about an existential threat, I don't think that the Israel-Iran case is sui generis when you look kind of globally and historically in terms of feeling that existential threat. And it's just that I don't think that the solution is to say, well, that high threshold that we've set for resorting to the use of force unilaterally should be weakened in order to deal with that. I think, again, to the other side of the system, the question is, to the extent that there are people in states who feel and are living under existential threat and do not feel protected, why isn't the multilateral architecture working? And what needs to be done differently? And then again, I'm going to hammer back on veto reform to shore up the international system for all of the coming challenges, which extend way beyond this particular crisis that we're dealing with right now. But I don't think that we can, in any of that, lose sight of the kind of North Star that whatever rules and systems that we have in place have to be able to be applied equally. And that is, I think, the risk of sort of extrapolating from individual situations. And so it's always a good check just for all of us to reflect on how would this rule be applied in reverse, and is it one that we would want? And I am very skeptical of the idea that there are 193 states in the UN, that anything near a majority of them would think that it's a good idea to have a rule where states can resort unilaterally to using force based on their unilateral assessment of even an existential threat.
Thank you, Tom and Becca. I was wondering, I have some final thoughts, but I was wondering whether Marko, Yuval, and you would like to respond to something, or whether something is missing that you would like to add, Tom and Becca, before I finalize with some concluding thoughts. Any of you? Yeah, Yuval? Yeah.
Yeah, just want to clarify. I fully agree with what was said. I mean, the law has to be applied in a principled manner and in an equal manner. So if on Tom's question on Palestine, if on the facts you would make the case that the Israeli project is about the elimination of Palestine, yes, I would argue the same thing. Israelis, of course, would say, well, Hamas is a proxy of Iran and shares the eliminationist agenda of Iran. So the war that started 2 years ago was actually part of this counter effort to push back on an eliminationist agenda. But if we were to agree on the facts, I don't think Tom actually argued the facts, but if that had been the factual situation, yes, I would argue that it would apply the same. But I accept that Becca's point. It's not a great. It's a very problematic system where states are making this call. But at the same time, we cannot expect states who genuinely and in good faith feel that they are under such a threat simply to sit and wait decades and decades for the Security Council to rescue them when that rescue team is never arriving. So one has to, in a way, choose between two evils in that regard. We are seeing how states are actually, I mean, the way in which states are moving is as a result is to basically move away from international legality. So that's also, of course, not a great outcome. Just on this, I do want to also take a small issue with this idea of that countries came out the way they came out on Iran because they are afraid of Donald Trump. I mean, of course, they're also afraid of Donald Trump. But we do see, we have seen now in the resolution on Iran, it was co-sponsored by 135 or more countries. This is a very, very broad swath of the UN membership. I know that when there are questions regarding the US policy vis-a-vis Cuba, there is almost consensus in the UN against the United States, and it usually is only the United States and Israel vote on the other side. So you see that in some areas, the United States is isolated. In some areas, it is very limited international support. But on this specific issue, it did have a lot of support. So one has to also, so I think it's too facile to say this is because people are afraid of Trump and they do whatever he wants to do. Sometimes they do what he wants them to do, but sometimes there is resistance and there is pushback. On Greenland, we have seen pushback. We don't see the same kind of pushback on Iran. So we have to be, I think, a bit more nuanced in the way we analyze state reactions. That's it.
Thank you, Yuval. Tom, you raised your hand. Did you want to respond to something? And maybe Marko afterwards, and then wrap up. I want to give the equal floor to all of you, Tom.
Yeah, all I wanted to say is that it's not apt to characterize this as a situation in which there's a demand on the state to wait for decades and decades for some kind of alternative solution. There have been alternative mechanisms. There was the JCPOA, and the actors involved here were involved in degrading it and withdrawing from it, respectively. There were alternative diplomatic channels, including ongoing negotiations. They cancelled them, seemingly on the basis of not understanding what exactly was on the table and generally clearly having a proclivity towards resorting to force. There are alternative international fora than simply the Security Council. First of all, one can go to the Security Council and force the illegitimate veto, get the 9-vote majority, and act on the basis of having the support of the international community and claiming the veto is illegitimate. Secondly, one can go to the General Assembly and seek a Uniting for Peace resolution. Thirdly, one can engage in all sorts of other multilateral mechanisms, all of which should, in the first instance, be mobilized towards diplomatic solutions and non-forcible solutions, and to claim that this was a problem of a state not being able to act except through unilateral force because it couldn't be held to ransom on the veto is just not accurate on the facts, because no alternative mechanisms were undertaken. First of all, with respect to credible and genuine efforts at diplomatic solutions, alternative non-forcible solutions, and then finally, ultimately, even if a resort to force proved to be necessary in the specific instance, which I don't think it was here on the facts anyway, there wasn't an effort to try and get any kind of multilateral buy-in for that or articulate a new rule that would be supported on a multilateral level and could be a change in the way in which we understand the resort to force. None of that was present. So on the facts, that's just not the correct way to characterize this. Even if it were, I think there would obviously be profound challenges associated with acting outside of the existing legal framework, but we're not close to that. So I think it's just not accurate to frame this issue in those terms and then to channel the debate in that direction when the facts don't support it.
Thank you, Marko and Becca. Do you want to add something? Wrapping up, Marko? Anything?
So I mean, just very briefly, most domestic legal systems work in the way international law works or doesn't work. If you look at humanity, 2/3 of humanity live in countries where the powerful break the law routinely and nothing happens. Yeah? Where people don't really act in good faith. And when you say, when countries determine in good faith, I don't think Benjamin Netanyahu and Donald Trump and good faith go in the same sentence or the same paragraph or the same page. And you cannot divorce the people making these decisions from the character that they have. Unfortunately, you can't, right? So, the international legal system is where most domestic legal systems are. where you have huge issues with compliance, where the powerful break the law routinely. It is what it is. The question is where we go from here. The problem that I see is that all paths from where we are, or 90% of paths from where we are, lead to even worse outcomes. Yeah. So the question is, what can be done to find that one path or set of paths which is the least bad, or where maybe there's hope for better outcomes? And again, I will simply reiterate the message. That starts domestically. That path starts internally. You cannot have rule of law or reasonable levels of compliance at the international system if you do not have governments that are domestically not in any way committed to compliance with the law. That's our core problem. And that's the problem in Israel. It's the problem in the United States. It's the problem in a vast majority of countries all over the world. And it is that problem that needs fixing. So that's where I will end.
Thanks. Becca, do you want to say something?
Yeah, I can't resist the wrap up. So, Tom did a lot of work for me here. I reject this idea that we have this binary between you either sit on your hands and wait for the existential threat to hit you, or you wait for the UN to come and save you. And Tom kind of laid out the multilateral options that there are, but also to remember it's not as though states don't have a ton of options for responding to existential threats themselves. The only thing that Article 2.4 did was take out of that toolkit the unilateral resort to force. That is all we're talking about here. And I think, again, sort of stepping back, we can surely, I hope, agree that when we're talking about a rule that would apply to all states in the world, keeping that unilateral resort to force out of the toolkit is a major accomplishment which we want to hold on to. As imperfect and broken as it is worth fighting for, and it is worth continuing to push for. And so, to the extent that we can hold to that. And then back to Marko's point about what is happening domestically and the role of international lawyers, a lot of it also is us getting out there and talking to regular people about international law in ways that make sense in their day-to-day lives. And so just to say more forums for doing that, I think is helpful to the overall project.
Thank you all very much. I wish we had more time. I know it's Friday evening. We can continue over and over and over, and there are so many things to discuss, and I hope we have this opportunity in person soon. I invited all of you because I have an uneasiness every time I walk into class, and I'm teaching a module called International Law and War. And I get these challenging questions from the students. I have to be very honest. I'm looking for a vocabulary that can be inspiring. And I have to say that every time I say this is an illegal, this is a violation of international law, full stop, it's not enough for me, and then I'm trying to find the words. And I have to admit that I'm still looking for these words. I'm very picky with the words. What are the words that could trigger some imagination, inspiration that we can...
Maria, can I barge in? So
Yes.
Maybe you want to give them the following example, that even in the best of countries, in the UK, only 1% of rapists go to prison. And 99% of rapes go unpunished. And we're not then going to say there is no such thing as criminal law, or the crime of rape is not really a crime, or, people who, if they're powerful rapists, should be tolerated. Maybe that's all you need to say, really.
Yeah, that's an argument that has been on the table. I'm still looking. I'm trying to find, the distinctiveness within international law, and not go and look for help from domestic law. But anyway, what I wanted to say is that I share an uneasiness, or maybe I have an uneasiness, and as an international lawyer, what am I doing? What am I saying? Do I make sense? The things I teach today, are they in practice that reminds me a lot of a piece of Fuad Zarbiyev in Igil Talk Again about aggression and some other things. And it's like, okay, where do we stand there? So I have to say that I'm challenged a lot. But for that reason also, I invited all of you, and I want to thank you for this wonderful, very rich discussion, where actually several points were further elaborated, clarified, and I heard more and more. I agree with you, I disagree with you, but and that was very, very nice, to be honest, to see the people who write in person. I want to finish with some really final thought. When Marko spoke of fidelity, came to my mind the work of Hirschman, Albert Hirschman. I work a lot on that, and I'm sure all of us were familiar with the exit voice of loyalty. What kind of loyalty do we show to international law? The exit that several actors speak, but I would say the voice, and the art of voice is very tricky. I think it's the most difficult thing. Who invokes? Who uses this voice? How is this voice invoked? Okay, and in what the bad faith, good faith argument there, I think we all agree, that if we take particular personalities, we cannot link them to good faith, whether it's Putin or Netanyahu or Trump or other leaders. But there is something about the voice, and not only the actors, but also the exercise of voice. And that brings me to my final comment. I wish Tom Frank was still alive, because Tom brought together all three aspects. He was institutionalist. He really believed in institutions, but at the same time had this massive wisdom of mitigation. So Tom acknowledged that the UN Charter could be adapted, but there were limits in this adaptation as well. So he was bringing elements of exceptionalism, of mitigation into the system. But he had the third element, which was very important, and that was dialogue. Dialogue and exchange of ideas and talking to colleagues, even those who massively disagreed. So I think Tom as a paradigm, he's very much missed nowadays. I really wonder, I'm not sure he would write about the death again of Article 2, Paragraph 4, but I wonder what he would write nowadays. And on that note, once more, I want to thank you all very, very much, because we may be surrounded by irrational political personalities who decide about our lives and the lives of millions of people. But at least, here, that was an exchange, I would say, of some kind of common rationality, all despite the fact that we have very different views in this regard. And I don't know if you would like to add something. I know it's almost an hour and 50 minutes. Everybody wants to go. But once more, I want to thank you very much. It's good that Yuval was not interrupted. But thank you all for engaging so thoroughly, for your ideas. Lots of food for thought, and definitely massive work for us international lawyers, whether either as practitioners or as academics or as teachers. I think that's it, to be able to talk and to exchange our views. No thoughts, no final thoughts. I think everybody wants to go. Thank you very, very much, all of you. And I'm looking forward to the next discussion. Thank you very much.
Thanks, everyone.
Thank you. Bye, everyone.
Have a good night. Bye-bye, all. Thank you.